You're listening to
Real Mysteries.
Episode 8: The Federal Trial Process.
I'm your host, Brenda Bennett, along with producers Rick Buchanan and Ken Sarkey. In Episode 6, we summarized some of the major evidence collected by the FBI and other law enforcement agencies that connected Timothy McVeigh, Terry Nichols, and Michael Fortier as perpetrators of the 1995 Oklahoma City bombing. Rick?
Well, what we included was actually just a small portion of the results of the investigations. According to Louis Freeh, who's head of the FBI at the time, from 1993 to 2001, in his autobiography, this case generated 3.5 tons of evidence, nearly 1 billion pieces of information. FBI agents conducted some 28,000 interviews, examined 13.2 million hotel reservations, and 3.1 million Ryder truck rental records, and more.
Here's an excerpt from our interview with FBI Special Agent in Charge, Bob Ricks.
The case was meticulous. I handpicked the investigative team that was put together and the best people that we had in the FBI to put this case together. So I had great confidence that any results that they put together would withstand scrutiny. We had people, primarily FBI, but we had people with the ATF. We had an evidence response team that had been put together, was the best in the country. So I was confident because most of the evidence that was presented had been obtained by the time that I'd left. It was refined to many great degrees, and those so-called conspiracy theories were all being run out to make sure that there was nothing there as well. Didn't keep other conspiracy theories from coming forward. But by the time that I had left and gone to work for the state, that was one reason I was willing to left. I actually asked Keating for a 2-month extension because I wanted to make sure that we were well on the way to having a successful prosecution in the case. And I was confident that we would be.
Ken, why don't you play us some of your interview with your daughter? She had an important role in dealing with all the evidence.
Okay, I can do that. I'm Ken Sarkey. I'm here at Cornerstone Recording Company interviewing my oldest daughter, Sergeant Christy Sarkey, who is currently with the Edmond Police Department in Oklahoma, formerly with the FBI in Oklahoma City, Oklahoma. Christy, it's been 20 years now, but do you remember where you were on April 19th, 1995 at 9:02 in the morning?
Yes, I remember very distinctly where I was at that time. I was attending college at Southern Nazarene University in Bethany, Oklahoma, which is about 10 miles away from where the explosion happened. And I remember I was in my dorm room. I had just finished one class, and I was headed upstairs back to my dorm room to retrieve some more books whenever I felt the ground shaking underneath me and heard the loud explosion, and then went up to my room and turned on the news and then saw what had happened.
Do you think that the Oklahoma City bombing influenced your decision to pursue a career in law enforcement?
Definitely, and I'll fast forward a little bit. Now I'm on the bomb squad, and that was a huge thought in my mind whenever I joined the bomb squad at the Edmond Police Department. But back to April 19th, 1995, I was actually going through the hiring process with the FBI at the time. At the time, it took about 2 years to get hired on, due to all the different levels of testing that you had to pass, and then they had to send the results to headquarters, and then they had to send it back to the field office here. So it was a bit of a lengthy process, but I was going through the hiring process at the time, and then was eventually hired on with them in December of 1996.
What were some of your duties there at the FBI? You were there for how long?
I was there for almost 5 years. I got hired on initially as a mail and file clerk, and then kind of worked my way up to squad secretary, and then was promoted to evidence technician, where I became a member of the evidence response team as well. I was responsible for all of the evidence division-wide there in Oklahoma City, and then also went out on crime scenes with the evidence response team, where I worked my first homicide.
The FBI sent you to Denver to help in processing that massive amount of evidence and documents in preparation for the McVeigh trial. Tell us about your role there.
Sure. In January of 1997, I was assigned temporary duty, or TDY, to the Oak Bomb Task Force. That was the code name, if you will, for the Oklahoma City bombing case. It was called Oak Bomb, OKBOMB. And I was stationed up there in Denver. They had a temporary command post set up there in Denver, and it was right next to the courthouse. So I lived there for several months, and my job was to assist in trial preparation for the discovery process, to be able to hand over every document, photograph, piece of evidence that the FBI had over to the defense for the discovery process. So as you can imagine, it was just volumes and volumes of paperwork and photographs. And beside the crime scene photographs, we had subpoenaed photographs from every media outlet, every citizen who may have been in the area who took photographs. They were all sending in photos. So there were just millions, literally millions of photographs that we had to copy to turn over to the defense.
So you had to have quite a filing system to number and be able to quickly access all those.
Yes, it was quite a meticulous and organized process, very, very detailed. And I remember seeing the crime scene photographs too, and just, I was just in awe because I hadn't been there when it actually happened. So it was my first glance at how horrific the devastation was.
That tedious job responsibility surely carried with it an emotional impact, didn't it?
Yes, it was very difficult, especially just knowing that all the children who died and that someone could actually do that and be okay with it just was beyond me. I just couldn't believe that another human being would do something intentionally to other human beings like that. I just could not understand at the time, and I still don't. But that's part of the reason why I'm in the job that I am today.
I remember you phoning home while you were staying in Denver and checking in with Mom and Dad. What was the atmosphere like there in the city and around where you're staying?
Well, it just so happened that the Super Bowl was going on during the time that I was there, and the Broncos had just won the Super Bowl, and I remember looking out the window of my hotel room, and there was rioting in the city just below me pretty much all night long, that whole night. I remember seeing SWAT police officers riding on the skids of armored vehicles down the streets, and there were vehicles that were being overturned and on fire. And I remember thinking, in contrast to the Oklahoma City bombing and the purpose why I was there, and then how quickly people forget how precious life is, that these people are out in the streets rioting over a football game. I just thought that was just unbelievable. I don't know, some people just lose sight of the big picture.
Right.
And to be rioting in the streets, and I'm there trying to do everything I can to bring justice for the victims of this, massive terrorist attack. It seemed very shallow to me.
Tell us about being a crime scene investigator and how you dealt with the emotions associated with that task.
Yes, I was a crime scene investigator for about 8 or 9 years prior to becoming a sergeant and going back to the patrol division last year. And that was a very, very rewarding job, but it was a tough job because, a lot of times we respond to death scenes, and that just breaks your heart to be there and know that somebody's loved one is gone. And but it's also very rewarding because it's my job to put the pieces together and to uncover all the evidence to make sure that, if a crime has occurred and someone did this to this victim, that we uncover all of the evidence and make sure that I locate everything in order to bring that person to justice. And that part of it was very rewarding because, if it is a death investigation, that victim can no longer speak for themselves and they can't tell us what happened. So it's my job to be as meticulous and methodical and thorough as possible to make sure that, we find out who did this to them and make sure that they go to jail and that they are brought to justice for what they did.
And I learned from talking with you during those times how important it is to know what the legal issues are and following protocol and gathering and documenting evidence so that an actual conviction can go through. That was especially significant to me to find out that law enforcement agents, FBI agents, really had to know the legal aspects of things. It wasn't just about catching someone, but it was about how to do everything the correct way so that it would hold up in court.
That's right. We always have to consider that and make sure that we document, photograph, collect, preserve the evidence, and preserve the chain of custody of the evidence to where we can say that the integrity of this evidence is just as it was the day we collected it at the crime scene. From the crime scene to our evidence room, property room, all the way to the courtroom, that evidence has got to be documented and collected and preserved and in pristine condition, and make sure that the chain of custody is maintained. So, yes, there's definitely a very methodical process that goes along with that as far as documenting it.
I also had a very interesting and informative interview with Pat Ryan, who was the U.S. District Attorney for the Western District of Oklahoma. He was on the prosecution team in both the McVeigh and Nichols trials. Now, because he was calling in to us from Mexico and on a cell phone, there are occasional glitches in the signal.
The FBI and it wasn't just the FBI, I want to make that clear. I mean, there were other law enforcement agencies that were part of this command force that did the investigation. But, they gathered every motel record for like a 7-state area for a 2 or 3 year period. I mean, there's like 30,000 motel records. Trying to find clues to the identity of particularly Terry Nichols, but also to establish McVeigh's involvement as well. Like 35,000 people. I mean, there was an incredible amount of detail, and all of that information that I've just discussed was turned over to the defense. We have the United States, or any prosecution, whether the United States or the state of Oklahoma, has the obligation to turn over anything that might be favorable to the defense to them prior to trial. Well, in this case, it was really hard to tell what was favorable to them and what was not, because so many of these people claim to be eyewitness testimony folks, people who say they saw Timothy McVeigh, whether it be in Alaska or Oklahoma City or Soviet Union. And so, is that favorable? I don't know. So we turned it all over. Didn't want to run any risk, so we turned over all what we call 302s, which are the witness statements taken by law enforcement. All of that was turned over to the defense. But it was a massive amount of effort and a massive amount of material.
The case against Timothy McVeigh and Terry Nichols was first randomly assigned to U.S. District Judge Wayne Alley, who served in the Western District of Oklahoma. His courtroom and office were just 1 block from the Alfred P. Murrah Federal Building. Both were damaged by the 1995 bombing. Judge Alley also had friends and acquaintances that were victims of the bombing. When he made the announcement that he would stay on the case, lawyers on both sides began making plans to appeal his decision. They argued that no member of the Oklahoma City judiciary could be impartial on an event of such tragic consequences so close to home.
When prosecution and defense lawyers in the Oklahoma City bombing case joined in common cause to push for his replacement as the trial judge, Judge Alley quickly and firmly refused to budge. He insisted that he could be fair and objective despite the damage to his courtroom and chambers. He also stated that he had not attended any of the bombing victims' funerals. Because of the possible prejudicial connections, Judge Wayne Alley was removed from the case. The 10th Circuit Court of Appeals was responsible for granting this request, and then appointed U.S. District Judge Richard P. Matsch of Denver, Colorado, to preside over the trial.
Well, it didn't take long before Judge Matsch was quickly presented with a number of defense motions, including the defendants' claim that they could not receive a fair trial anywhere in Oklahoma. They asked for a change of venue and got it. The trial was moved to Denver, Colorado. Mr. Ryan, as lead prosecutor in the case, it must have been hard on you, too, the inconvenience of moving the trials to Denver?
Well, as you probably know, I resisted that. And we held a week-long hearing, 1 or 2 week hearing in front of Judge Matsch to try to keep the trial in Oklahoma. But I think once the 10th Circuit had disqualified every judge in Oklahoma, which I found to be very surprising. And they appointed Judge Matsch, who was what I'd call the senior trial judge in Denver, Colorado. it was pretty clear to me even before the hearing that we were headed for Denver. And, you know, I can appreciate that decision to move the case to Denver in the sense that it made a cleaner record and one less subject to appeal. But I still find it surprising that, you know, the Boston Marathon trials are going on in Boston, the New York Trade Center trials went on in New York. But yet there was this move, which I think was not just judicially motivated, but I think somewhat by the Department of Justice themselves, to move the case out of Oklahoma. I found surprising. And it was truly shocking to me that they would feel that every judge, even judges that were not in Oklahoma City, judges that were in Muskogee and Tulsa, would be disqualified. I found that very surprising. Still do.
Next, the defendants wanted to be tried separately. This issue was crucial to Terry Nichols, who was not in Oklahoma City at the time of the bombing. He wanted to distance himself as far as possible from McVeigh. Judge Matsch granted Nichols' request to be tried separately. McVeigh's trial was first, but the start was repeatedly delayed as the defense team requested time to study the mound of evidence and documents.
The defense team amassed 35 lawyers. Some estimates of the total cost of the defense ran as high as $20 million. Some members of the defense team traveled to the Philippines, Israel, England, Ireland, and across the United States, searching for any information that could link the bombing to a terrorist group. Stephen Jones of Enid, Oklahoma, was the lead defense attorney.
The federal government's case was handled by a team of experienced attorneys. The chief prosecutor was U.S. Attorney Joseph Hartzler of the Central District of Illinois. Mr. Ryan, who were some of the other people involved on your prosecution team?
There were some lawyers that served some different types of roles. Sean Conley was in both cases, and he was primarily a legal expert and handled most of the motions and writing of briefs and responding to briefs and that type of work. A phenomenal lawyer. But Larry Mackey and Beth Wilkinson were both also involved in the prosecution of both Nichols and McVeigh.
And so you got to know some of the relatives and family members and survivors of the victims and their stories. In fact, I read that you made it a point to personally talk to the relatives of all the deceased victims. Is that right?
Yes. I mean, it wasn't, I wasn't steeped in law enforcement when I was appointed United States Attorney, so it took a little bit of thinking about the position when I got there. But I think within about a week or so of assuming the position of United States Attorney, I talked to the people in my office and told them that I believe that we should talk and meet with every one of the victims of the Oklahoma City bombing. Certainly all of the injured victims and all the people who had lost loved ones. And when I did that, I had no idea the commitment that we were making, and it was a good commitment. I'm glad we did it. But these meetings that we would hold individually with families, I thought would last 30 minutes. And they ended up lasting most of a day.
Wow.
It's very important. And I understand that now in retrospect. It was very important to these families that you understood exactly who their loved ones were, what they accomplished in life, and the various qualities that they possessed. So that took quite an effort. And Lynn Anderson in my office was the lawyer, was principally charged with setting up those interviews. And I believe if she didn't sit on every one of them, she sat on the majority of them, the vast majority of them. Vicki Behenna and I sat on the majority of them as well. There was incredible people with incredible stories.
Now, tell us about that special symbolic article of clothing that you wore. The white cowboy hat.
I've given that to the museum, so I don't own it anymore.
Okay.
I need to get a replacement hat. But, quite honestly, we have a saying in our law office when we pick a jury and we're thinking about witnesses, we say, they're not from around here if they're not from Oklahoma. And I know it doesn't probably mean much to you, but, I'm the one, and Vicki Behenna and Lynn Anderson were the ones that the victims identified with. We'd met them, they knew us, we'd held meetings with them individually, but also as a group. And so I thought that wearing the hat would make them identify more closely with the prosecution of this case, and that's why I won.
Someone from Oklahoma was on their side.
Exactly. They could see me and they go, I know him. And he's on our side. He's been working hard for us. At least I was hoping that would be the message that was conveyed.
Holding the trial in Denver, Colorado, created a problem for the bombing survivors and the families of the deceased. Many of them wanted to attend the proceedings, and, in fact, many would be called as witnesses. Attending the trial in Denver, some 700 miles from Oklahoma City, would be costly. Victims organized and lobbied Congress for help. As a result, Congress passed 2 laws regarding victims' rights.
The first was a new federal statute required that when a court changed the venue of a trial out of the state to a location more than 150 miles away, a closed-circuit television broadcast had to be provided to the original location of the crime.
And the second was the judge was prohibited from excluding victims from attending a trial just because they might testify about the impact of the crime on the victim or the victim's family. Oklahoma's Governor Frank Keating also helped raise funds to assist victims in attending the trial.
It was determined that McVeigh would need security during the potentially lengthy trial. Rather than house him in a local jail, the federal government elected to build McVeigh a cell in the federal office building next to the courthouse in Denver. It had no windows, but McVeigh had a bed, cable TV, and it was monitored 24 hours a day. In the courtroom, a wall was erected to shield the jurors from the view of the spectators. For their protection, the names of the jurors were not disclosed. Eventually, on March 31st, 1997, the jury selection process began. It took 16 days to seat the 12-member jury, chosen from a pool of 324 Colorado citizens. It was time for opening statements in the case of the United States of America versus Timothy McVeigh.
The federal trial against McVeigh started out with the prosecution outlining the evidence that would tie McVeigh not only to the bombing, but also proving his motive. It also included heart-rending tales of the victims and lives lost. It was not only persuasive, but an important part of the government's presentation.
The law allows the government to put on victim witness testimony. For one thing, it sets the scene of the crime itself. And we had an obligation to prove the death of everyone that we claimed died or who did die in the bombing. So, for example, we called a surviving representative from each of the offices in the Murrah building to identify the people that were in the building, to talk about each one of them briefly, to identify where they had last been seen in the Murrah building on the morning of April 19th. And we couldn't do that very well for the daycare center because no one survived. But for all the other agencies, we did that. And, of course, their testimony was incredibly powerful. And it really went to the heart of what McVeigh and Nichols were trying to do. They were trying to kill these people in the building, and they did. So I remember we started the McVeigh trial with Helena Garrett, who lost her son, Tevin, who is one of America's Day kids in the daycare center on the second floor. Her testimony was extremely powerful. It was an extremely effective way to start the trial. And we tried to, if you will, sprinkle witnesses like Helena throughout the trial to keep reminding the jury of just how vast and horrible this crime was.
Yes.
They were, amazing people who had a unique perspective, of course, on their loved one, and were able to communicate it very effectively, far more effectively than any lawyer could do.
The prosecution wanted to dispel any notion that McVeigh was some kind of soldier or patriot. They would show that he was instead a murderer who had killed innocent men, women, and children while running from the scene.
When it was time to hear from the defense, the trial had its first twist. It was a 2.5-hour opening statement by lawyer Stephen Jones. No traditional courtroom tactic of raising reasonable doubt, but a blatant statement that McVeigh was innocent, something the facts did not support.
Attorney Stephen Jones also read the names of all of the 168 people killed as a result of the bombing. At the time, no one knew the impact on the jury, but the tactic angered many of the families of the victims. Journalist Phil Bacharach extensively covered the Murrah Building bombing, and in 1996 interviewed Timothy McVeigh at the federal penitentiary in El Reno. Here's an excerpt from our recent interview with Phil Bacharach.
I gradually had become close to a couple of people on the defense team whose job specifically was kind of to be his, quote unquote, the conduit of information between McVeigh and Stephen Jones, and they did not get along. McVeigh did not feel he could trust Jones, and Jones had difficulty with his client.
I do give Stephen credit for taking on a very difficult assignment in defending McVeigh. The evidence against McVeigh was overwhelming. He couldn't reasonably hope to win the trials. I know Judge Russell, who was the chief judge in Oklahoma City at the time, had called some lawyers and to try to defend McVeigh. And when I say lawyers, I'm talking about very capable lawyers, with experience in major criminal matters. And he had a very difficult time finding anybody who'd want to defend this. I mean, you can imagine. Mm-hmm. And Stephen agreed to do it, and I give him credit for that.
And as the trial moved on, the tactic of the defense was to engage in a lengthy and detailed cross-examination, looking for any small discrepancy in a witness's testimony.
Well, we called in both trials, I think, 501 witnesses, approximately 250 in each trial. And it was put on pretty efficiently. I mean, 250 or so witnesses in McVeigh, I think, were put on in about 5 weeks. We had another 3.5 weeks of jury selection and then ultimately later jury deliberation and then the death penalty phase. But, it was put on pretty efficiently. It's contrasted, for example, with O.J. Simpson, where they put on half the witnesses in 6 times the time.
Pat, what can you tell us about the testimony of Michael and Lori Fortier?
Well, frankly, I don't think we needed the Fortiers. I don't think They added a whole lot. They maybe had a little background in terms of the fact that McVeigh had been to the building before, that he had effectively scoped it out. And I think that helped establish that he knew exactly who was there. And he knew that daycare center was there. And he'd been there that Easter before, and he couldn't help but see the children's finger painting and whatnot that were on the north walls, glass walls of the building on the second floor. But, Fortier testified that he and his wife helped make this fake driver's license for McVeigh in the name of Robert Kling, the name he rented the Ryder truck at in Kansas. He talked about the fact that they were selling stolen guns at these gun shows. So I think he added something, but quite honestly, he was using meth and other things that really took away from his testimony. And quite honestly, I don't think we needed him to prove the case. I think we could have proved it without Fortier. If I could just add something to this, I mean, one thing that victims and any non-lawyer had a difficult time understanding, and it's understandable why they would, is why Fortier didn't get more of a sentence than he did. Why wasn't he charged with the bombing? And the truth is, and the fact is, that Fortier, we had zero evidence against Michael Fortier except what he said coming out of his own mouth. And he was given the opportunity to talk to the government, to law enforcement, and our office, but it was done so under the understanding, which is very common, that nothing he said would be used against him. Otherwise, he wouldn't talk at all, and he wouldn't get anything. And so that was the understanding, and we could use it against others, but we couldn't use it against him. This is done, I would say, I won't say every case, but it's certainly not unusual. It's very, very common. Because as you can imagine, in the days following the bombing, we were desperate to find out all we could. We didn't know how many people were involved. We didn't know how many McVeighs were out there, Nichols were out there. So they were, desperately trying to get anybody that would talk and would tell the government who else was involved with this. It turned out, in my opinion, there's no one else involved, and we've identified them all. You can't say that with 100%, but you're pretty confident based on a number of things I could talk about if you want. But, so anyway, getting back to Michael Fortier, I don't think he added a lot.
Okay.
I don't think we needed him, but and he was sentenced with every crime we could charge him with, which amounted to 13 years, which he served the 13 years, less his, then he gets off a little bit for good behavior. He got a year or so off. So, I mean, that to me is the import of Michael Fortier.
And what about testimony from Timothy's sister, Jennifer McVeigh? She was important to the case because she helped establish McVeigh's motive for the crime, which was an intense hatred for the government and its agencies.
Well, you know, the only thing that I really have a vivid memory of regarding her was her identification of his handwriting.
Okay.
You have a right in a criminal case to require the defendant to provide a handwriting exemplar. But on a death penalty case, what are you going to do if the defendant refuses, which McVeigh did? I mean, you can't. There's nothing more you can do.
Oh.
So Jennifer McVeigh was called primarily to identify McVeigh's handwriting because we had several things that he had signed that we felt were incriminating, and she was able to do that. Beyond that, I don't think she had a whole lot of value.
Okay.
As a witness.
Yeah, I noticed just what I saw of McVeigh's writing and like the note about do not tow this car.
Right.
All his writing seemed to slant backwards to the left, just from me looking at it. But
yeah, one of the exhibits I remember was that I thought was particularly effective in closing was we had his handwriting from the Robert Kling signature on the Ryder rental truck. And the graphic artist had superimposed those same letters from other writings he had done.
Mm-hmm.
And, of course, it was the exact same signature. I mean, didn't need an expert. Just any jury could just take those same letters, ROBERTKLING, from other things he'd written. And they're identical to the signature Robert Kling on the Ryder truck roll. It was very effective.
I know McVeigh was smart enough to advance in the military and so forth. It seemed like IQ of 126 or something. But in so many ways, it seemed like Dumb and Dumber. You know, using a $250 getaway car and the tag wasn't on it. And...
Yeah, well, first of all, I think he was poor. I mean, I don't think he had a lot of money. He wasn't worried. He hadn't had a job in some time. You know, he was raising money through the selling of guns at gun shows around the country.
And bumper stickers.
I mean, I don't think he had a lot of money. I mean, maybe for the inexpensive car. But, I mean, a lot of people have wondered about the failure to have his license tag on and, you know, could he have possibly gotten away and all that. And, you know, I don't think I can add much to what probably most people would conclude. I can only imagine the apprehension, the fear, the anxiety that one would have to feel who was detonating a bomb that they intended to blow up everyone and kill everyone inside that murder building. So I can only assume that he made the mistake of not getting the tag on there. He probably didn't want the tag on there when he left it in Oklahoma City on Easter Sunday, because he didn't want anybody to run the tag and run the registration and the like. But the reason for not putting it on that Monday morning, I can only assume was due to anxiety and an interest in getting out of Oklahoma City as quickly as possible. But, you know, not being in that position, it's pretty hard to judge. But obviously it was a critical mistake he made, fortunately.
Right. I think in my reading and studying of all the events that I could get my hands on, especially when I heard about Michael Hurtig and Todd Bunting, the Army private or whatever.
I know who you're talking about.
Yeah, from Fort Riley, who rented a truck the next day after McVeigh. And that seemed to explain to me the John Doe number 2 theory. And as far as other conspiracy theories, just that it was possible for a couple of guys like that to pull off this crime.
I mean, you know, that's one thing that, of course, has led a lot of the conspiracy theorists to believe that others were involved. And I was satisfied when the FBI interviewed the 2 Fort Riley soldiers that they, in fact, were the guys that were originally identified as John Doe 1 and 2 in the sketches that were drawn by the Elliott's Body Shop personnel. I mean, it's one of those things that you just had to see all the evidence And, I remember when the FBI went to Bunning's house and they asked him if he had a ball cap. He came out with his Carolina Panther flame ball cap. I mean, it was just obvious to the investigators, and it was obvious to me that he's the guy that they were really identifying as John Doe number 2. And the fact that John Doe 1 sketch really did look like McVeigh. So we were satisfied, as much as one can be, that there were not 2 other men in addition to McVeigh and Nichols. And secondly, we know that Nichols did not go to the Elliott Body Shop. I mean, McVeigh went by himself. He was caught on a video camera at McDonald's, a mile or so away from Elliott's just prior to winning. So, it was pretty logical that Hurtig and Bunning had been in there since McVeigh. They'd been there. McVeigh rented the truck on Monday, and I think they were there on Tuesday, if my memory serves me correctly. And so it was natural that Elliott's people would recall them instead of just McVeigh by himself. But I certainly was satisfied that they had misidentified John Doe 1 and 2. And of course, the evidence was, again, overwhelming that McVeigh was, in fact, Robert Kling, the renter of the Ryder truck. I mean, he had stayed at the Dreamland Motel in room 25. He'd ordered the Chinese food. I mean, he'd signed under the name of Timothy McVeigh. I mean, it was pretty clear that he was the renter of the truck and not Bunning and Hurtig.
By the close of the government's case, McVeigh had been linked to the Ryder truck and the truck tied to the bombing. His arrest clearly placed him in the vicinity of the bombing at the right time. Based on the testimony of the Fortiers and Jennifer McVeigh, the prosecutors had painted a picture of McVeigh as a rabid domestic terrorist determined to strike the government he hated.
The defense team tried its best to persuade the jury that a crime the magnitude of the Murrah bombing required more people and greater expertise than possessed by just McVeigh and Nichols.
It took 4 days of deliberation by the jury to reach a decision.
When you walk in a courtroom in a case that you've helped investigate, a case that you've decided should be prosecuted, and you've decided that for a reason. You believe the evidence is there, you believe the defendant is guilty, and you represent the United States. When you stand up in court and say, my name's Pat Ryan, I'm the United States Attorney, and I represent the United States in this matter, I mean, you start with some leg up, if you will, on the defense. Granted, you have to prove your case beyond a reasonable doubt, but that's usually not hard to do. I mean, we get to select the cases that we wish to prosecute, and by and large, 99% of them are guilty. And so it's not hard. It's a little harder maybe in a case like Oklahoma City bombing, in the sense that, you're being moved out of your form state. You're moved to Colorado, a state that, when I talked to the DA in Denver after I got there, they were 1 in 17 in their last 18 death penalty cases. They'd only gotten the death penalty 1 time out of the 18 times they'd asked previously. So Colorado was not a state like Oklahoma where people, by and large, favor the death penalty. I think it's just the opposite in Colorado. So I don't think getting the guilty sentence was particularly hard, but certainly getting the jury to agree that the death penalty was appropriate is always difficult, and I think it's particularly difficult in Colorado. And I mean this no disrespect to people in Colorado. Obviously, this is an issue that people can disagree on, and I understand that.
Timothy McVeigh was found guilty of all 11 counts against him in a unanimous verdict. The penalty phase of the case only took 3 hours of deliberation before the jury returned with a sentence of death.
Terry Nichols was in a much better legal position to defend himself than McVeigh. After all, he was in Kansas at the time of the bombing. He wasn't tied to the Ryder truck rental and had not announced his intentions to the Fortiers or anyone else. Patrick Ryan, who was on the prosecution team for the federal trials against McVeigh and Nichols, judged his chances of success at about 50-50.
Still, there was a great deal of evidence to show Nichols' involvement with the crime. At Terry Nichols' house in Harrington, Kansas, the FBI had found 5 rolls of blasting caps, his fingerprints on a receipt for purchasing 2,000 pounds of fertilizer, some 55-gallon barrels, similar in material to what was found at the Oklahoma City bomb site, There is a bomb-making instruction book with 14 fingerprints of Terry Nichols. They found McVeigh's backpack and rifle, the phone calling card, and numerous weapons. He had also left incriminating documents and letters with Lana Padilla, his ex-wife. Nichols had hidden a package in her kitchen that contained $20,000 cash and a note to McVeigh that said, "You're on your own. Go for it." Mr. Ryan, as a prosecutor in the federal trial against Terry Nichols, what can you tell us about Lana Padilla's testimony?
I think she was very helpful in Nichols' trial. While I think she had some feelings for Nichols, being her former husband, the fact that he left this note with her before he went to the Philippines and the storage locker and all that she found, I thought that was very effective, and I did think that helped in the Nichols prosecution.
And the $20,000 cash in the kitchen?
Exactly. And the ski mask and the other things that were found in his locker. And the note was very incriminating, I thought. And it looked to me like the note and some of his behavior after that, I think, suggested to some jurors that Nichols really did not want to participate any further. He'd participated to a degree, and we think he bought ammonium nitrate. We think he helped build the bomb and all that. But I think some jurors believe that he really didn't want to be in Oklahoma City. And, of course, as you know, he wasn't in Oklahoma City at the time of the bombing.
The defense team focused their attention on saving Nichols from the death penalty.
The jury deliberated 40 hours over 6 days and returned a verdict on December 23, 1997. Nichols was found guilty of conspiracy to use a weapon of mass destruction and 8 counts of involuntary manslaughter. He was found not guilty on the crimes of the actual use of a weapon of mass destruction and destruction by explosive.
The sentencing phase became legally dramatic, and by that I mean the jury could not reach a unanimous decision on what Terry Nichols' punishment should be.
That's correct. They didn't come to a unanimous decision on the guilt phase. They convicted Nichols, as you know, of the conspiracy to bomb the Murrah building with the intent of killing the people inside. But they did not. They reached manslaughter verdicts on the murder counts and not findings of murder. So we knew going into the penalty phase that it was going to be a rough road to hoe with these jurors that were selected Nichols for them to vote for the death penalty. And ultimately, I wouldn't say they hung up, but they were out for a long time, and it was obvious to me they were struggling with it, and I frankly didn't think they would come back with a death penalty verdict in light of what they'd done on the guilty phase. So Mr. Tiger, the defense counsel for Nichols, moved for a mistrial on the sentencing phase. I know it sounds like we're a mistrial, but it only applied to the penalty phase, had no application to the guilt phase, which was over, concluded with. And when he did so, remember Sean Connolly and Larry Mackey and I discussed this out of the presence of the defense in the court and came in and said we would agree because we were fairly confident, that Judge Matsch would give him life imprisonment, which we considered to be, at that point in time, given what the jury had already done, a victory. I was very worried, and I think they were as well, that the jury potentially could come back with something less than life, which I think would have been very difficult for the victims of this horrendous crime. So that's the way it happened.
Ultimately, Judge Matsch declared a mistrial and took over the sentencing personally. On June 4th, 1998, he sentenced Terry Nichols to life in prison on the conspiracy count.
In the federal system, there is no parole, so this sentence effectively put Nichols away for life. Nichols was also fined $14.5 million, which was the original cost of the Murrah building. The verdict and sentencing did not please everyone. But we'll save that for our next episode, as we visit with Sandy Elliott, lead prosecutor in the state of Oklahoma's case against Terry Nichols, and Wes Lane, former Oklahoma County District Attorney. We'd like to thank you for listening and for your responses. We'd love to hear your comments, questions, and suggestions, and you can do that on our realmysteries.us website. which also has our links to Facebook and Twitter, along with a lot of photos and other related documents. I'm Brenda Bennett, and this is realmysteries.us.